Okay, hi everyone. I guess we're the last panel before lunch, so I'm sure everyone's hungry. Hang in there. My name's Neal Marder, and I head up Akin Gump's class action practice. We don't have a PowerPoint for you. We don't have any slides, and we don't even have a moderator. But trust me, we're ready to roll. So this discussion is going to be about arbitration, and I think it's fair to say that in the last decade or so, since Concepcion's solidification of the judicial approval of arbitration agreements and class action waivers, there's really been an onslaught of arbitration provisions that find their way into arbitration agreements. These aren't my statistics, but those that keep them tell me that there's been an increase of over 50% of arbitration filings since Concepcion, and most notably, over 90% now of consumer contracts include arbitration agreements, 90%. So where we find arbitration agreements most commonly are in, not surprisingly, contracts involving consumer goods and services, financial products, and at least attempts to include them in employment relationships. The Supreme Court has been very active, very recently very active, in connection with their interpretation of arbitration issues. And we're going to start out talking about some of the most notable recent Supreme Court cases, make our way into a discussion about some of the kind of risks and rewards of having an arbitration provision, pros and cons, maybe get into some best practices. So Dan, why don't you start us off? You're a pretty well-known plaintiff's lawyer from the plaintiff's bench. Lamps Plus just a few days ago. Why don't we talk about Lamps Plus and get this kick-started there?
All right. My name is Dan Walker. I'm a shareholder at Berger, Montague, and we do a lot of class actions. I do a lot of antitrust class actions in particular, so not as much on the consumer product type cases, but and Lamps Plus, which came down recently, was a data breach case essentially. Apparently a hacker tricked the company into handing over the personal information on a large number of Lamps Plus employees, I think something like 1,300 employees. And one of the employees, I believe, had a fraudulent tax return filed under his name with his information and sued the company on behalf of a class of employees who had their information stolen. And the company invoked the arbitration clause in his employment agreement. And the court compelled arbitration, but said that he could arbitrate on a class-wide basis with the other employees. And the court essentially avoided the Supreme Court's decision in Stolt-Nielsen versus Animal Science, which said that if an arbitration clause is silent as to whether it allows class-wide arbitration, then class-wide arbitration is not available. That's what the Supreme Court said in 2010. The court avoided that by saying, well, the arbitration clause that the plaintiff signed in Lamps Plus was ambiguous. It could be read either way, and under California contract law, you construe the terms of a contract against the drafter, and so if the plaintiff wanted to do class-wide arbitration, then that would be allowed. And that was appealed up to the Supreme Court, who overturned it and said that in following on Stolt-Nielsen, if an arbitration clause is ambiguous, if it can be read either way, then class-wide arbitration is not allowed. So I think, everyone is trying to figure out what this means, but I think the clear upshot is, under Stolt-Nielsen, if the arbitration clause is silent, it must be individual, and if it's ambiguous, it must be individual. So the only way you're going to have class-wide arbitration is if the agreement is explicit that that's allowed. And I don't do a lot of counseling of companies that are writing arbitration clauses, but it seems to me that it's going to be the rare case where a company puts into their contract that they want to allow class-wide arbitration. And so I think it's fair to ask whether that decision is the end of class-wide arbitration. And so, in thinking about this, I guess I had some questions for the folks here who actually do counsel companies writing class-wide or writing arbitration clauses, whether they think this is the end of class-wide arbitration and whether this might be a situation of be careful what you wish for. And I'm thinking in particular about the Uber case in California where thousands of employees filed arbitration demands, which Uber in their contract had to pay the filing fees for, and then I believe asked the court whether they could get back into federal court because they didn't want to arbitrate thousands of individual claims for the reason that, for the same reasons that class-wide adjudication are generally, in a lot of cases, more efficient. So I'm wondering if any of you want to weigh in on those questions.
Sure. In terms of whether or not Lamps Plus effectively closes the door on class-wide arbitration, I think, like Dan mentioned, unless you've got a clear, conspicuous provision in the arbitration agreement saying that class-wide arbitration is going to be allowed, then the Supreme Court seems to be indicating that it's not going to happen. But I think you're going to see, and this is just a hunch, but I think you're going to see certain other mechanisms start falling into place because right after Epic Systems, for example, the House Democrats put a bill out there. I think it was the reforming, it dealt with reforming employment justice issues and things like that. And so that bill is currently out, and the House Democrats and the Senate Democrats have taken on support behind it. And so I think you're going to start seeing the legislature stepping in if they feel that this is really tilting in one direction in a way that's not good for the country and good for whether it's employees in this case or for consumers as a whole. I think you'll also see courts, similar to how you saw courts right after Epic Systems, start finding those narrow carve-outs that they can to push back against the Supreme Court's ruling a little bit. I think you'll start seeing that where courts maybe, the indication is you're not going to be able to really do anything with the arbitration clause or the arbitration provision in general, the class-wide arbitration waiver, if you will, but they might be able to find other grounds to strike the arbitration agreement as a whole, whether they find that it's substantively or procedurally unconscionable. Dan touched on this. In the Uber case, who's paying the fees? There's courts out there that basically have said that because the filing fee would only be some couple $100s for plaintiffs, if the defendant or the employer or the manufacturer in that case isn't picking up the tab for the arbitration, then they're going to strike the arbitration agreement as a whole. Similarly, courts have pushed back on whether or not there's adequate consideration, especially in the employment context, whether or not continued employment is consideration for an agreement to waive the class-wide arbitration or the agreement to arbitrate in the first place. And so I think you'll start seeing more courts pushing back on some of these things to the extent that they feel that this is heading in the wrong direction.
I think you have to ask yourself, first of all, I don't think it's the end. I think that I think the message of the decision, as well as other decisions coming out of the Supreme Court, is if you want it, you darn well better be clear about it, conspicuous, and not leave it scratcher because I don't know how many of you out there counsel your clients on arbitration provisions and class action waivers and whether to include them or not, but it really goes against the trend of including those provisions. And I don't know about you folks out there, but I have a lot of respect for arbitrators, and I do a lot of cases that end up in arbitration, but I don't want an arbitrator deciding class-wide issues under Rule 23. You also have to be concerned about appeal rights in an arbitration, whereas if things don't go your way in court, although you may not be able to get an immediate appeal, you are certainly, at the end of the case, having an opportunity to appeal, whereas in arbitration, and we're going to talk about this, one of the benefits and one of the downsides of arbitration are things like appeal, evidence, how much evidence an arbitrator or arbitrators are going to allow in or not allow in, as opposed to a court proceeding. So, while I'm not second-guessing the lawyers that were advising Lambs Plus to include it, I don't see many, at least in the clients I represent and the provisions I review, I don't see many class-wide arbitration provisions these days in any event.
Yeah, and kind of consistent with Neal's point, when I first read Lamps Plus, the thing that struck me was, why wasn't there a class waiver in the arbitration agreement to begin with? I do a lot of drafting of arbitration agreements, and it's almost commonplace, especially after Stolt-Nielsen and some of the other cases, just simply include a class arbitration waiver. The Supreme Court has said that they're enforceable, and a lot of agreements now just simply include them. So Lamps Plus never would have been at the Supreme Court if the arbitration agreement had been drafted more clearly to begin with. That's one thing that really strikes me about that decision. In terms of, is this the death of class arbitration as a whole, there's a lot of context, particularly in the consumer realm, where you have arbitration agreements that are not that aren't mandatory. So there's still going to be a lot of opportunities for class arbitration. And one thing also kind of consistent with what Pravin said, from what I've seen with enforcing arbitration agreements in court, and it's something that I do pretty routinely, courts will find any opportunity they can, particularly if they don't like the setting, to invalidate an otherwise valid agreement. So when you draft them, you have to be very careful to ensure that that you draft an agreement that's going to be fair to both parties and that is going to give both parties actually what it is that they're looking for.
I think I want to touch on a point that Michael mentioned. Why wasn't the class action waiver in the Lamps Plus arbitration agreement, if you will? And I think part of it has to deal with there was a lot of unclarity before Epic Systems, right? And so employers and manufacturers, whoever, on the defendant side specifically, were hesitant to put in class action waivers if they didn't contain some sort of opt-out or something like that. Just having a blanket class action waiver in there gave people pause about whether or not your arbitration agreement was going to get struck. And so after Epic Systems, which hasn't been very long, you're talking about a year or so, there's been a shift in how you draft these arbitration agreements now, because you can put that in pretty much wholesale without having to worry about having an opt-out or anything like that. And so employers, manufacturers, hospital systems, you name it, either one, we're not putting in class action waivers, or two, we're including them with opt-outs. And so I think it brings up a practical point, which is, if you're on maybe the defense side, you need to start thinking about going back and looking at your contracts and taking a look and saying, hey, we have an opt-out. We don't need that anymore, especially after Lamps Plus. Or, hey, we need to put in our class action waiver if that's the direction that we want to go in.
I think the more interesting issue would have been if it was clear and conspicuous and the court didn't find that it was ambiguous and therefore raised concerns about whether or not it was binding. Because then you deal with the issues that were some of the justices had concerns about, like due process. Is this really a fair process to those absent class members who may not have similarly signed arbitration agreements that had the class action provision in it? That would have been the more interesting question in my mind.
So and I want to get back to that point too, but I'm wondering on the be careful what you wish for point, whether you have any discussions with clients about whether they want to get rid of the possibility of doing things on a class-wide basis on their end. I mean, obviously, a win on a class-wide basis can be a good thing for defendants, and if you're going to have, it seems to me, from the plaintiff side, typically, that if an arbitration clause doesn't get rid of a case altogether, then you may be in a worse position having to litigate, arbitrate thousands of claims that are otherwise identical, where you can't invoke the defendant protections in Rule 23.
Yeah, I think in the Sixth Circuit there was a case, I think it was the Gaffer's case, where it's that scenario. You had an individual who sued in that case in court on behalf of a putative class. He was not subject to an arbitration agreement, whereas 50%, and I think the number was some like couple thousand employees were subject to an arbitration agreement, whereas the other 50% weren't. And so as a company, I think you need to consider some of these things up front, right? Like how your agreements have been in the past and where you do want to end up with them, because in that case, all of those couple thousand employees who were under arbitration agreements now ended up in arbitration, and so you've got those claims, but you didn't avoid the class action, and so now that company is defending on both fronts, and the situation that you pretty much don't want is where they are, where they're at, where they're expending resources in both directions.
So this is always the risk, it's not one size fits all. And when AT&T made a decision in Concepcion to attempt to enforce an arbitration provision, just like what Uber did, the realization is that if you're right, you may be litigating individual cases brought by professional plaintiffs firms who make their career out of litigating against a company because they learn that company's business issues upside down, and you're dealing with them. You can't get them to agree on a settlement agreement not to sue you. At least in California, that violates the Business and Professions Code. So, these are not easy decisions, but I think many of my clients that include the provision do it as a deterrent, number one. Number two, they're dealing with consumers who have claims that they believe can be effectively resolved in an inexpensive way. Trust me, that is not always the case, and in many instances, it turns out to be more expensive and a bigger headache than what they had hoped.
Yeah, I mean, the one provision that I've seen in particular that has come back to bite clients, particularly when courts were focused more on the unconscionability element of class actions. I saw a lot of agreements or arbitration in general, a lot of agreements that would bend over backwards to be fair to the plaintiff. And one of the things they were doing was they were putting in a panel of 3 arbitrators, saying to kind of get rid of any claim that the panel's not going to be fair. We're going to have a panel of 3 arbitrators. A panel of 3 arbitrators gets very expensive very quickly, and particularly with a smaller consumer claim, there are some clients who are saying, well, okay, we got our arbitration provision, we got it enforced, and now we're having to pay for a panel of 3 arbitrators. So is this something that we want to continue to do? Do we even want to continue to pursue enforcing these agreements? And I think, and generally, they've come out on that they have done that, and I've seen them start to move away now from the panel of 3. But that's one of those considerations that I think where people have put provisions into a class or into an arbitration agreement and then started to back off a little bit.
So one other question I have that sort of arose from a couple of things you mentioned, including the statistic about the increase in arbitration filings is, and of course I'm sure there's no statistic on this, but I would be curious to know how many cases are just not brought anymore, either because they're kicked to arbitration initially or the arbitration clause is a deterrent. And certainly we've seen, I mean, going back well beyond Concepcion, I guess, the shift to arbitration being broadened and class waivers being tightened up, that class-wide adjudication is being restricted to some extent by these, and I don't know that anyone really knows the full extent. And I was wondering what thoughts are on the panel here about systemic concerns, either for clients, whether, you know, be careful what you wish for point, but whether there are concerns beyond that you think about or discuss with clients or discuss, you know, amongst yourselves about, you know, about how far this has gone down that road.
Well, I guess I'll start. You know, I think that if the courts, particularly in California where I'm from, or the legislature see that individuals, for example, workers, have claims that aren't being brought and they're not having their rights adjudicated because of class action waivers doing too good of a job, I think they're going to step in, and they are stepping in. I think right now there's some legislation we've talked about in preparing for this, where Democrats in the House and Senate are proposing legislation to essentially overturn EPIC systems to ensure that workers can have direct access to the NLRA to pursue employment claims and try and prevent employers from rigorously enforcing class action waivers as a condition of employment. And in California, I call it kind of a push-pull. California judges are actively attempting to carve out areas to allow consumers, employees to pursue claims. For example, there's a case called McGill where the plaintiffs sought public injunctive relief and used that as an argument why there should not be an arbitration provision with a class action waiver enforced. Similar to an argument that was made in the context of PAGA, where you're representing, actually acting as an acting attorney general, doing something for the public. So I think if the legislature doesn't step in, you'll have courts, particularly in states like California, that will look for carve-outs to try and chip away at class action waivers and arbitration provisions.
Does the Shine case from the Supreme Court, I guess, come in here too? Because wasn't an aspect of that the request for injunctive relief, and whether it was appropriate for an arbitrator to decide in part on that? Do you know?
Sure. So just a little background on the Shine case generally. So it was an early 2019 decision from the Supreme Court. It was a unanimous decision dealing with delegation clauses, and a delegation clause is essentially a provision within an arbitration agreement that says an arbitrator can actually be appointed to determine whether the arbitration agreement is enforceable. Those clauses themselves have been enforceable for a number of years, going back to, there was a 2010 Supreme Court decision, or right around there, called Rent-A-Center, and there were decisions before that. In Shine, the court looked at the arbitration provision and said, regardless of the delegation provision, there's just no basis to enforce this agreement, and we're not going to do it. And there had been kind of a circuit split. What the Supreme Court said was, even if you think it's entirely groundless, we are still going to have an arbitrator determine the scope of the arbitration agreement and the enforcement of the arbitration agreement, because arbitration is a matter of contract, and that's what's set forth in the agreement. And there's been a number of cases, including there were a few out of the Fifth Circuit within the last couple of years, where that delegation clause alone has been used to destroy a class action, where essentially the putative class member had signed had brought a class action. The delegation clause was raised and enforced, and at that point right there, the class action was kind of killed.
My thought about Shine is similar to Lamps Plus. I mean, I personally don't find anything necessarily remarkable about the decision. Yet the Supreme Court is getting involved in cases in the context of class action waivers, arbitration, to try and provide some guidance where, in my mind, they didn't necessarily need to. I mean, Shine says that if you're clear, conspicuous, and unmistakable in the language of a provision providing for delegation, there will be delegation. And if you're not, there won't be. Am I oversimplifying?
No, I mean, I think that's about it. I think part of why the Supreme Court steps into these cases so frequently is because lower courts, and particularly the state courts, just ignore them. I mean, I've seen countless examples of there will be a new Supreme Court decision on a certain arbitration issue. You go try to enforce an agreement in state court on that same issue, and the state will come up with something else, whether it's a tortured unconscionability kind of analysis or some other carve-out of or an exception. You know, courts still don't like these agreements, so I think that's part of why we see the Supreme Court stepping in so often, is because state courts are still, state courts in particular, are still very hostile to the arbitration agreements in a lot of states.
Yeah, I think that's probably right. I mean, Justice Kagan brought up a point in a footnote, I think, in Lamps Plus saying, or maybe it was at oral argument, I think, where she pointed out that, you know, it's funny that the court continues stepping into these arbitration agreement cases because the court generally has liked to stay away from creating a federal common law on especially state interpretation issues and things like that. But the courts had no problem, you know, walking into these types of cases. But I think it's because there still are a lot of courts out there that, especially at the state court level, that like to strike down arbitration agreements and arbitration clauses. And so I think this is the court sort of stepping in, trying to enforce what they had under the FAA and you know, giving arbitration clauses sort of their due. But it's interesting, right? Because part of what goes under the FAA is that an arbitration clause has to be bilateral, and there has to be assent in order for the agreement to actually hold. And there's a threshold question out there as to whether or not these are actually bilateral agreements, or they're, you know, touched upon by an earlier panel. These are really just some sort of adhesion contract if you're talking about from a consumer manufacturer perspective, or whether or not, you know, employees or you name it actually have any sort of ability to say, no, we don't want to sign these. It really doesn't seem that way, but I think that's an interesting question that sort of pops up.
I mean, isn't that really what Concepcion addressed? Before Concepcion, the rule of law in the Ninth Circuit under Discover Bank was you could make an argument of adhesion and an agreement being unconscionable. Didn't Concepcion basically say that the FAA controls?
Yeah.
I mean, is there still an argument to be made of adhesion or unconscionability in this world we're living in?
I think some of the lower courts have continued down that path even after Concepcion. I think the Supreme Court, especially given how the court is currently constructed, has given us their thoughts and continue to with Ethic Systems and with Lamps Plus. But I think there are a number of federal district courts out there that still try to narrowly carve that piece out and push back wherever they can. You know, federal circuit courts pretty consistently have then taken what the Supreme Court has said and overturned a lot of these district courts. But I think, you know, wherever district courts can, certainly some are trying to still grab onto whatever vestiges are left. But I think it's going in the other direction.
I mean, for my clients out on the West Coast, we've created kind of a checklist after Concepcion where it's kind of a menu of things to tick the box on things that they should consider including in their arbitration provision to get over an unconscionability argument. That's what happened in Uber. I mean, they ended up doing everything right. They had a provision paying for it. I think they had a provision making the form friendly to the plaintiffs. It was friendly to Uber as well. They had a number of provisions provisions that would intentionally give them an opportunity to overcome an unconscionability argument, and they were successful. And now they're individually arbitrating, hundreds if not thousands of cases.
I think there was a question out there.
Mark Gross from Conrad. I work mostly in the securities area, but one of the things we're now being challenged with potential imposition of mandatory arbitration of securities fraud. Two questions. I was struck with reading Concepcion and Epic by the court's reliance on alleged empirical data showing that arbitration is faster, less costly than class actions. I'm wondering, one, is there any further data now that goes either way with that? Because it strikes me that what you're suggesting is not necessarily the case where they're like in Uber or in other large impact cases. The other question I have, though, is I've been struck by the fact that so far in the securities area, while there's been an effort by some forces to impose mandatory arbitration, so far the corporations have been slow, if not reluctant, to jump on. Alibaba had a mandatory arbitration in its IPO. It was sued. It ultimately settled the case without ever invoking the mandatory arbitration. Johnson & Johnson there was an effort by a shareholder, Professor Hal Scott, to impose mandatory arbitration by a bylaw. I don't think he counted on the fact that J&J is opposed to doing that. So what is the differential in the calculus in the securities area then compared to consumer, if you can tell us?
Hey, Mark. I'll take a shot at that, and I think you and I have been adverse in some cases before in the securities area. I don't know of any statistics. I only know of my own. And in my own world, particularly in the commercial context, where you have commercial parties arbitrating, it's not a pretty picture in terms of arbitration being more expeditious and less expensive. To the contrary, when you are dealing in the commercial context, and it's not a consumer case, you're litigating over delegation issues, selection of arbitrators, scope of discovery, what parties are bound by an arbitration provision, particularly when you have a non-signatory that's affiliated with a party who signed an arbitration. You're dealing with a lot of issues that end up being litigated just like they would in court. In the securities context, I raised this issue before with why would, like in LAMS Plus, you want a provision that provides for litigating class issues in arbitration. I think some of that same thinking applies in the securities issue. Whether you're on the plaintiff side or the defense side, and you have a lot of great retired judges who turn out to be arbitrators, do you really want those issues being resolved in an arbitration where you deal with issues like presumption of reliance, all of the issues that you and I deal with in the securities context, particularly with the limited rights of appeal. So I don't see it happening. I could be wrong, but I think the issues are too complex, they're too thorny, and they're the type of issues where you don't want relaxed evidentiary rules as you have in arbitration, and you definitely don't want to limit your appeal rights. So another Supreme Court case that came out recently, we talked about briefly, was Epic Systems. Any particular thoughts on that decision and its impact?
I think for me, Epic Systems, interesting enough, right? The most interesting part of Epic Systems to me, and I think part of this touched on a little bit earlier, was the reaction to Epic Systems by the legislature. Epic Systems itself doesn't depart from what the court's been doing for the last 9-10 years. And so finally, I think now the legislature turning around and taking some action, the House and Senate Democrats, in terms of the in terms of trying to ban mandatory arbitration and class action waivers in the employment context, I think that's probably telling. We'll see how far that can go, especially under the current makeup of the House and the Senate. But I think, this, not trying to dive into politics too much, but I think the upcoming election cycles will be very interesting as to how some of these issues play out and whether or not we see any additional legislation that comes out not just in the employment context, but also within the context of consumers as it relates to either manufacturing, financial institutions, things like that, in a way that would protect consumers a little bit more. To me, that's the most interesting part of EPIC systems. I think I agree that a lot of these opinions by the Supreme Court are pretty much expected at this point, given the makeup of the court, but I think the reaction to it outside of how district courts and how judges have been sort of trying to carve out wherever they can, I think that's probably the most interesting piece.
I think the dissent in EPIC, I guess it drew a lot on Concepcion, and which really I think was started exposing the really strong split in the court. But you can see these dissents are cited in all of the subsequent dissents. Like the four on the liberal side are really setting out like a pretty clear dissenting view as a group about what their problems are. And I think EPIC was interesting because they talked a lot about consent and this idea that, if, as the majority keeps saying, this is an issue of consent, is there really consent? Right. Is an employee in Madison who works for a big employer and, presumably needs and wants to keep their job, really given consent to sign or not an arbitration agreement in the same way that, a Fortune 500 company negotiating with their supplier over an agreement has consented to waive their Seventh Amendment rights and go into a private adjudication. So to me, on my side, I feel like it's interesting to watch that develop, and I noticed in both EPIC and LAMPS Plus explicitly calling for the legislature to do something about it. I think Ginsburg noted, she said, the time is urgent now to do something about this if the legislature agrees with us that this isn't really what arbitration was meant to be and not what the FAA was meant to enact.
Yeah, I think Justice Ginsburg has pointed that out in both cases, like you're saying. And it's funny, I mean, the arguments are pretty much, you can expect them. I think, and I could be wrong about this, but I don't think Justice Breyer's opinion in LAMPS Plus cited anything except his dissents in all of the previous cases. So pretty much where everybody falls at this point, and it's just it's down sort of ideological lines at this point.
So you practice primarily antitrust, and I think just from Mark's question about securities and some of the back and forth here, my takeaway is, notwithstanding Concepcion and the rule of law in favor of arbitration, this isn't a one-size-fits-all, and it's not right for every case. Can you imagine an antitrust case being arbitrated on a class-wide basis? What's your thought about that?
Yeah, I mean, certainly it would have to be, on a class-wide basis, if there was class-wide arbitration, it's possible. It would depend on the scope of discovery. And in my experience, recently I do a lot of pharma antitrust, but a lot of other things too, is that it doesn't seem to me that the defendants want to save money on discovery and go through it quickly. It seems like there's a lot of third-party discovery that the defendants want to do in a lot of these cases. Sometimes it seems eclipsing what we're trying to do. But if you could agree to have, enough discovery and the claims were big enough that it wouldn't be swamped by the expert costs and all of that, I think it could be done. But, the problem is without a class-wide mechanism, you would need an individual plaintiff with a large enough amount of money at stake to want to do that. I mean, that was what the dissent in Concepcion, I don't know, it was Kagan who said, you'd have to be a crazy person or a zealot to want to bring, $1,000 or $10,000 antitrust individual claim on an individual basis, because you'll spend $1 million or $2 million, 3, 5, whatever, litigating that, even just looking at expert fees and the cost, not even counting attorney fees. So yeah, I think it could be done on a class-wide basis. I don't think it can be done realistically without a class mechanism.
And if you look at, for example, the complex or the rules under JAMS, for example, that deal with discovery, even in the complex cases, it's not going to provide the type of discovery that you would need in an antitrust case or a securities case, right?
I think that's right, although I can imagine a situation where the defendants don't want to be bound by that limitation either, and I can also think of situations where the antitrust claim arises from something else, either a government investigation or, another case, a False Claims Act case or something like that, where it would be easy to get all of the documents or a lot of what the plaintiff needs without running afoul of the JAMS rules, without having to go through, So I think it depends on the case to some degree, but you're right. I mean, the discovery limitations would be difficult.
So Mike, you mentioned you counsel clients on arbitration and draft provisions. I'm your client and I come to you and I say, I got a business where I'm dealing, it's a nationwide business. I'm selling a lot of widgets to consumers all over the country. Should I have an arbitration provision in my consumer contracts? What's the benefit? What are you going to tell me?
So one of the benefits in the consumer area is you protect yourself from a runaway. The thing that gets general counsels fired is when you get the surprise $90 million verdict on a consumer claim or a claim that you don't think is going to be worth that much, and that's not that much. So with an arbitrator, you take away a lot of the sympathy, and you get somebody who's going to look more coldly at the facts. I represent a lot of healthcare clients, many of whom know that they're going to be, if you look at the medicine of their malpractice cases, they're going to win on 70%. But if you look at the sympathy and you look in front of a jury, that number's probably going to be flipped, and where you're going to have a big runaway potential. So the one thing arbitration does do for you, and I think one of the biggest benefits, particularly in the consumer context, is that it gives you some measure of certainty. The flip side is that one of the big criticisms from a lot of general counsels is that arbitrators won't pull the trigger on a defense verdict. They're always trying to split the baby, but at the same time, you're not going to get that runaway. So I think it depends what your tolerance for risk is and where you want to come out in that balance. But I think that's one of the big benefits in the consumer context is preventing the outlier verdict.
Neal, I have a question for you. So, having defended a lot of these cases in the consumer context, have you seen where there's just boilerplate arbitration language that's just introduced without some sort of thought process behind whether or not arbitration is really right for this company or right within this industry, and it's come to backfire on somebody?
I'm dealing with that right now. Not in the context of a consumer issue, but two parties to a redemption agreement in connection with a merger transaction involving one party selling of their units. And they agreed that if there's any dispute, they would arbitrate, and the provision could not be more poorly drafted. And as a result of that, we are litigating, it's like a law school exam, everything under the sun. Delegation, we're litigating whether an affiliated party who's not a signatory is bound by the arbitration provision. We're litigating scope of discovery. We're litigating the selection of the arbitrator. And notwithstanding the fact that we could have argued that with respect to delegation, for example, some of these issues should be decided by the court because it wasn't clear that the issue should be delegated, we've capitulated and agreed to litigate in the context of the arbitration because we know that if we litigated that in court and there would be appeals, motions to stay, and so we rather have a result that can't be appealed so that we could then, if we're right, go ahead and take discovery in the court proceeding that we wouldn't otherwise be getting in an arbitration. So I think it happens. Maybe not as that common, but it does happen. And I think good counsel advising corporate America these days after Concepcion, like in the Uber case, are ticking the boxes and making sure that they can defend an unconscionability argument. But many of these provisions have been in agreements for a long time prior to Concepcion, and I think it's a question of dusting them off and making sure that they're valid.
Right. Yeah, no, I think part of the takeaway, especially given where the Supreme Court has been heading, for me is I think arbitration clauses and arbitration agreements aren't a one-size-fits-all, right? I think some good thought needs to be placed from the client perspective, from the attorneys who are drafting, whether that's outside counsel, in-house counsel, as to what your goals are as a company. You have to understand similar to how from a business perspective we understand the industry that we're in and what we're trying to accomplish. I think with these arbitration agreements and these arbitration provisions, I think you have to understand who you are, what your goals are, where you're heading, and think about what the potential downside risk is going to be with including some of these. You don't want to end up in the situation Uber is in. And so you need to understand your goals very, very clearly and look at a couple of things, whether it's you're drafting an arbitration agreement because you're a new company or it's part of a new product or something like that, or whether you need to dust some of these off and you need to really take a look at what you've got out there. So I think understanding that it's not going to be the same for everybody and not just including the boilerplate language that goes in with, oh yeah, the arbitration agreement and the arbitration provision is going to be good, let's throw in a class action waiver and we're gonna be all dandy down the road. I think we really need to put in some good thought into what we're trying to accomplish and know that so that there aren't issues like Uber down the road. Anybody have any questions?
We have a few minutes for questions. If you are advising clients on these arbitration provisions, there are some pretty basic things to ask them to think about. We talked about cost shifting, absorbing the filing fee so the plaintiff isn't going out of pocket. You can include a confidentiality provision, form selection, trying to make it as convenient for the plaintiff as possible will put you in the best position to ensure enforceability. Things like that you should think about if you're going to advise your clients to include them.
Yeah, and I know this is probably a no-brainer, but definitely know the law in your jurisdiction, because in my jurisdiction, if you've got a confidentiality waiver, it's a 50-50 shot as to whether or not your arbitration agreement is going to hold. Some courts have found that by virtue of including a confidentiality provision in your agreement, you're going to end up tilting the scale in favor of the employer who's going to have seen these things and disadvantaging whether it's an employee or a consumer or whatnot. And so courts of 50% shot have been striking these down. So I think, it's a no-brainer, but know the jurisdiction you're in.
Neal, let me ask you, have you found as you've counseled clients on these over the years that you've shifted in terms of how aggressive you are in terms of avoiding the unconscionability?
Yeah, that's a great question. I just think it's a balance. There's certain things that the client doesn't want to and shouldn't give up, but other things that I think are easy. Nowadays, should you have an opt-out box for them to check or not? After McGill, courts now, the Northern District of California, Judge Seaborg is litigating right now the issue of whether or not, notwithstanding Uber, the plaintiff really was aware of the arbitration provision where there was a pop-up screen that kind of got in the way. There's plenty of issues that can still be litigated. After McGill, is it really public injunctive relief they're seeking, or is the heart of their claim private relief? I think there's certain things you can do about it in an arbitration provision, other things you just can't. And I just think, to your point, you really got to know your client and understand their business objectives. Okay, I think we have a short break, and then it's lunchtime, so thanks, everyone.